This video explains what happens at planning inquiries. If you're an interested party in a planning appeal, enforcement appeal, or indeed any other type of case where an inquiry is held, then keep watching to find out why cases are decided by the inquiry's procedure, what happens prior to the inquiry, what happens at the inquiry, and where to find out more detailed advice and support. Inquiries are normally held for complex cases or where there is likely to be a lot of local interest, such as large-scale housing or commercial developments. Around 5% of cases received by the Planning Inspectorate are decided by inquiry, and the procedure is determined by the Planning Inspectorate after the case has been submitted. The other procedures by which a case is decided are hearings or written representations. Before the inquiry, the local planning authority sends us any copies of letters of support or objection about the application that they received from local people while they were considering it. These are fully considered by the inspector who decides the appeal. If you did not write in at the application stage and now have something you would like to say, then you can send us your representation about the appeal. You should do this on the case summary page or by writing to the Planning Inspectorate. Make sure you submit your representation within the deadline. There is no need to repeat matters you have already raised, and any new points should be succinct. Late comments may be returned and not considered by the inspector. If you want to see what the appellant and local planning authority have written, you will be able to see copies of all the appeal documents on the local planning authority's websites or at their offices. The Planning Inspectorate will notify the main parties of the dates and location of the inquiry, which will be held at a venue local to the proposed development site, typically at the local authority's office, village hall or a community centre. So, what happens at the inquiry? The inquiry will be led by an inspector. In most instances, the inspector decides the case and issues the decision. The exception to this is where the Secretary of State is the decision maker, in which case the inspector will write a recommendation report. The purpose of the inquiry is to allow for the presentation of detailed and technical evidence and for the cross-examination of expert and other witnesses by the opposing party. The inspector will take an inquisitorial role to ensure that evidence is thoroughly tested so that he or she can make a properly reasoned decision. The parties will normally be represented by advocates. As well as the appellant and the local planning authority, some interested parties are entitled to appear and give evidence. Inquiries are open to members of the public, and although you do not have a legal right to speak, the inspector will normally allow you to do so. If you want to speak at the inquiry, it is important that you are there when it opens, because this is when the inspector will go through some routine matters, tell everyone about the timetable and the order that the proceedings will take, and ask if any interested people want to speak at the inquiry and will register their names. When speaking, you need to think about what you want to say and how you want to say it. Some people prefer to read out a brief statement giving their views. If there are several people with the same views, it's a good idea for one person to speak on behalf of the others to avoid unnecessary repetition. An inquiry may take 1 or several days, or in some cases even weeks. The length of the inquiry will depend on the complexity of the case and the number of witnesses involved. At some point during or after the inquiry, the inspector and the main parties will undertake a site visit. A written decision is usually made several weeks after the inquiry. We recommend that you read our guide, which contains lots of practical advice. See the link in the description of this video.